Hi, everyone. I'm Rohit. I'm the co-founder and CEO of Stilt. We provide financial services for immigrants. And today I have Sara with us. Sara is the co-founder and chief operating officer of Legalpad. Legalpad makes it faster and easier for startup founders and teams to get US work visas. And she will be helping us answer a lot of questions that are on every visa holder's mind given the current crisis. Today, we are going to discuss how H1B visa holders are getting impacted by layoffs and the various options that they have to stay in the country during this crisis. People in these 60-day grace period, what if they have a job offer, right? And now the visa is in transfer, but it hasn't been transferred yet because USCIS is not responding to applications on time. What should someone do in that case?
So it's always good for you to file for you to have the employer file for an H1B transfer as soon as you get the job offer.
Mm-hmm.
Unfortunately, there is no premium processing at this time, and this is across the board.
Mm-hmm.
So that's something to consider because it will take a little bit longer. But the good news is that USCIS is still running. They're still reviewing visa petitions, and it's still, in as much as you can be during COVID, like business as usual. Ordinarily, when you transfer from one company to another during a time of layoff, the company is able to file for premium processing, so that way they can get an approval right away, or rather within 2 weeks once you file. Unfortunately, premium processing has been suspended for the time being. And there's also this concept of portability. So basically, when you are transferring from one company as an H1B employee to another H1B company, to another company as an H1B employee, usually you can start on your new H1B with the company as soon as the petition has been submitted to USCIS. Unfortunately, that hasn't always been the case for the 60-day grace period.
Okay.
So generally speaking, you do have to wait until the end, until the petition has been approved, and that can be a little bit tricky because there is no premium processing.
Got it. So you are saying, based on how things are right now, even if you get a new job offer and they file for transfer, the transfer needs to happen within the 60 days of submission.
Okay.
Only then
right.
You'd be able to work. So if if the transfer hasn't been finalized, even if you have gotten a notification of receipt of transfer, even then you should ideally not be working for the new employer. What about H1B visa holders who have been furloughed? Are they considered unemployed?
So this is a really tricky question because legally speaking, employers are not allowed to furlough H1B employees.
Okay.
This is actually a term called benching. So essentially, when a company files for an H1B or sponsors someone for an H1B, there's this document called a labor condition application, which I like to think of it as a sort of mini application that they need to submit to the Department of Labor to basically ask permission from the Department of Labor to hire an international worker for the position that they have. And when you sign off on that document, when you submit that application, you actually you basically sign off on the fact that you promise to pay the H1B employee their wage for the entirety of the time that they're in the US. So being furloughed, I'm assuming that means you are not getting paid your standard wage. And that actually is grounds, that's essentially a violation on your employer's end.
Got it.
By keeping you on payroll but not actually paying you. There is a way for companies to actually keep their employees if they feel that they need to furlough them in order to cut costs. So one way is, transitioning H1B workers to part-time H1Bs. because part-time H1Bs are permitted.
Mm-hmm.
And so, when they're working in part-time status, that way you'll be able to only pay them, still have to pay the hourly rate for that, but it'll be cut in half essentially.
Is it minimum 20 hours per week for part-time H1Bs?
That's right.
Okay, cool. Let's move on to another common situation that many people face. Let's say both spouses are on H1Bs, and one of the spouse has now, one of them has lost their job. They can ideally go on H4, but how does that process work, and what's the timeline for that?
Sure. So they can they can go on H4. So you'll have to file something called an I-539, which is basically changing your status while you're in the US. And that's something that you're perfectly you're entitled to as a spouse of an H1B employee. However, H4 visa status by itself does not grant work authorization.
Right.
So if you're an H1B visa holder, and you've been laid off, you transition to H4 status, and you're going out to interview and you find another job, you will also need to make sure that you have an approved, something called employment authorization document, or EAD. It's essentially a card that you'll need in order to verify your employment, your employment eligibility for the I-9 when you start a job. And so the other tricky part of this is, as an H4 visa holder, so the dependent of an H1B, the only way you can get an EAD is if your spouse has an approved I-140. So only after there's been an approved I-140 is when you are qualified to apply for an H4 EAD.
Got it. And what's the timeline for H4 if someone just got laid off and applies for I-539 for change of status to H4? Is the time frame for approval of that less than 60 days generally? And what if the time frame for approval is more than 60 days?
So that being said, usually when you submit an I-539 change of status, you are able to stay in the US while it's pending. There's no premium, and there's never been premium processing for I-539s, so it will take a while. It really depends on where you're living, and then you can look up the processing times online for that.
Got it. And let's take it one step further. Let's say you have a dependent already on H4. And in this case, let's say you have I-140 and that H4 comes with an EAD. What happens if someone with an approved I-140 is laid off, and what happens to the H4 visa holder or H4 EAD?
Yeah, that's right. So that's essentially their visa status. So the H4 status is contingent or dependent on the primary H1B visa holder status. So if that primary visa holder will need to leave the US, then that H4 visa holder no longer has H4 status.
And for the H1B visa holder, even the approved I-140 doesn't help in any way?
It does not,
okay.
Unfortunately.
Okay. Now, let's say someone laid off from their job, and now they want to stay in the US. We discussed briefly some of those options before, but let's go through all the various options that someone can pursue to stay in the US or to increase their chances of staying in the US and then continuing or transitioning to work either immediately or later on.
Right. So yes, if you're on an H1B, you will have that 60-day grace period. Most people will. There are some restrictions because you can only take that 60-day period, I believe, once. So if you've used it up before, you should talk to your attorney to figure out whether you are still qualified for the 60-day grace period.
Okay.
So there's that. Another piece is to transition onto a B visa, so
Mm-hmm.
B1, with the intention of it being temporary, however,
Mm-hmm.
because you cannot use the B1 to work
Mm-hmm.
in the US.
Mm-hmm.
You can do it to do business activities, but
Mm-hmm.
that's pretty much it. And it may be a bit tricky. USCIS could find the intent problematic, as I stated earlier, because the B1 is really meant to be like a business tourist or like a tourist visa. And it's hard to make the case that you intend to be a tourist when you've been living here for a while.
Mm-hmm. So 60-day grace period, possibility in some case to apply for B1 or B2, trying to find another job and applying for a transfer
Right.
is another option. But in that case, you're saying the transfer would need to be approved within 60 days.
Yes. And also there is no premium processing
Right.
at this time.